The Supreme Court recently upheld an Andhra Pradesh woman's decision to change the surname of her minor son born from her late husband after her remarriage. A bench of justices, Dinesh Maheshwari and Krishna Murari, said that after the demise of her first husband, being the only natural guardian of the child, we fail to see how the mother can be lawfully restrained from including the child in her new family and deciding the surname of the child. On the direction to include the name of the applicant's husband as stepfather in documents, the Supreme Court said it is almost cruel and mindless. The Times of India spoke to Mahalakshmi Pavani, senior advocate, Supreme Court of India, and asked her to explain the importance of this judgment.
This judgment reflects the social reality of today's times. So what they have done is it's nothing new. They have only reiterated the legislative enactments, that is the Hindu Adoption and Maintenance Act of 1956, and with regard to the Hindu Adoption and Guardianship Act of 1956. Here, categorically, what happens is the father is the natural guardian of a child, but with his demise, the Section 6 of the Hindu Adoption Act categorically gives that guardianship thing to the mother. So she becomes the natural guardian of a child who is a minor in absence or in the demise of the father. So unfortunately, the trial court and the High Court did not accept this, and they did not give permission to them, to her, to change their name. So it was a long drawn battle, but Justice Dinesh Maheshwari and Justice the other judge, Krishna Murari, had settled it, and that's the correct thing. So the mother is the natural guardian, and she has every right to give the child in adoption or change the surname. The mother cannot change the surname of the child if she's a divorcee. But if she remarries somebody, and she wants to change the name of the child to that adopted father's surname, she will have to take the permission of the father, her husband, and then change the name. And under the Adoption Act, Section 12 of the Hindu Adoption and Maintenance Act, where a father or a mother adopts a child, then they can give that the child will and have to sever all relationships with his family of birth and take the adopted name of the father. In that case, it's possible. But where the biological father is alive, she will have to take his permission. No, there is no, I mean, how do you misuse this judgment? In fact, they have reiterated the legislative enactments. These acts are there. The Hindu Adoption and Maintenance Act, the Hindu Minority and Guardianship Act is already there. Probably with this judgment, people are now more aware, the married woman or the mother is more aware of her rights and who exactly is the natural guardian of a child in the absence, in the demise, when the father is deceased. Yes, a child can change his surname after attaining majority. It's not compulsory that, see, actually a surname, it is a kind of a name that you adopt. It's a family name, and it shows your ranking society in social state circles, your status, your ranking, your lineage, your culture. So that is a kind of from which home you come from. But if the child does not want to carry on with the stepfather's name, it is at the child, after attaining majority, can go before a notary and give a change of by affidavit, and then give a publication in newspaper saying that I have changed my name. According to Section 12 of the Hindu Adoption and Maintenance Act, the adopted child, it actually it severs its relationship with the family of birth, and the adopted father, takes the child into his custody or his adoption. So it is but natural the child will take the stepfather's name.
A Times Online report.